Hi, my name's Jane Wells. I'm a mediator at GoodLaw Family Mediation Service. You may have seen my previous video, and the video today I'm going to talk to you about is the benefits of mediation. So you hopefully have seen a little bit about mediation, that we've advertised our services, and I thought it would be really helpful perhaps to just start again and explain really why I would say that mediation is a benefit, and it's something that separating couples should be considering before they consider any other service when they've separated and want to talk about arrangements of finances and arrangements around their children. But I think the main benefit of mediation is to avoid a matter going to court, which for most parties causes a lot of stress and anxiety for each of the separating couple, and is certainly not ideal when you're talking about children in particular. It also avoids parties having to go and see solicitors. It's not a process which I would recommend you don't have advice from solicitors, but the advice that I would be recommending you would have is advice during the mediation process. So it would avoid you having to go and see solicitors separately and using solicitors to actually resolve the process, which can be much longer and also cause quite a lot of conflict and difficulties between the parties. It's a confidential process, that's extremely important, which means that when you come into mediation, everything that you discuss with the mediator is confidential between the two of you. That hopefully enables you to feel that you can openly discuss issues between you and not be worried about any binding agreement being reached. Now, that is one of the issues that needs to be clarified for mediation, is that it's not a legal and binding process, and you will need solicitors if you want to have a court order or an agreement, a legal agreement between you. The other benefit, I would say, is that if we're dealing with issues around children, we put the children at the forefront of our discussions, and we focus very much on what is in the best interests of the children and share in the mediation what each of you feel is best for your children. I would say it's probably a quicker process. You're probably aware that it can take months, even years, to go through the court process. With mediation, the process involves a number of sessions with the mediator, normally between 4 to 6 sessions, obviously depending on each individual case. And they will be, the time between each sessions is very much dependent on what the mediator and the parties are trying to deal with, but they're normally between the region of 2 to 4 weeks, maximum intervals between them. It's also, I would say, a process that is likely to be much cheaper than going to court. Now, this shouldn't be the reason to mediate, but certainly a lot of us, costs is one of the concerns that a lot of us have, and clearly if we can have a process that isn't as expensive as going to court or spending money on solicitors, and if it's a process that benefits you and your family, then this is highly recommended. There is currently a voucher scheme which the Ministry of Justice has brought forward, and this provides a contribution of £500 towards the costs of mediation. There's also legal aid available, and this is based on a party's income and their assets, and the mediator will assess the eligibility for legal aid. We are lucky to be able to offer legal aid in this practice, and the mediator will obviously assess your eligibility. If you are eligible for legal aid, then the mediation will be free in its entirety, and also the other party will get the first session free. It will also mean the MIMES interviews will also be free of charge. If neither of those apply, and in respect to the voucher, it only applies if you're discussing between you children issues, then we offer a fixed fee for mediation, and the details are on our website. And finally, when we're looking at benefits, I would say the largest benefit for mediation is that you own the outcome of the process. So the mediator's role is purely as a manager of the process, but the outcome is yours. And it's very much outcome based. My aim and the mediator's aim is to assist you in reaching a solution that works for both parties. And if we're looking at children in particular, to help the parties to look at how they can parent their children in a cooperative and a collaborative way, and to assist them if they want to into entering into a parenting agreement. When a mediation comes to an end, it will either come to an end if the parties feel that it's got to a stage that they no longer need the assistance of the mediator. They may not have reached a final resolution, but they feel that they can manage matters on their own now. Or they reach a final resolution, and then the mediator can in fact prepare a final document which is called a Memorandum of Understanding, and that document can be provided to solicitors who can then formulate a court order or a binding agreement for the parties. So if the mediation is successful, then that is how the matter ends, and then the solicitor's involvement is quite brief in that they only need to prepare those documents. So I hope that's been a bit helpful. It's very much a sort of quick nutshell of the benefits I think the parties have by coming into mediation. It's certainly a process that I would recommend. And just to be clear, we do screen for domestic violence and child protection concerns. So before mediation even starts, the mediator would see each party individually for a MIAMS meeting, and part of that meeting would be to assess whether there are any concerns for domestic abuse or child protection. Clearly, this has to be a safe process for both parties. If you've got any questions at all, then please feel free to add these to any comments or on our website. Thank you for listening.